For this week's installment of Rochelle's Daily Wire Video Edition, we visit the Fifth Circuit in a case on May 22 called Franchise Services of North America. If that decision had gone down the wrong way, the Fifth Circuit would have given lenders and dominant creditors a virtual veto over the ability of corporations to file voluntary Chapter 11 petitions. The bankruptcy court in Mississippi had certified a question to the Fifth Circuit, which the Fifth Circuit accepted. The certified question asked the appeals court to decide whether golden shares or blocking provisions were enforceable in bankruptcy. In her decision for the Fifth Circuit by Circuit Judge Carolyn King, she declined to bite that apple, but instead what she ruled was only on the case before her, those facts, nothing else, nothing broader about golden shares or blocking provisions. Judge King had a case where a creditor was owed $3 million. In addition, in substance, that creditor also had purchased for $15 million all of the preferred equity of the corporation, and it was convertible into about 50% of the common stock. As part of the overall transaction, the corporate charter in Delaware had been amended to provide that all shareholder classes had to vote for authorizing a Chapter 11 petition. So, after this company filed Chapter 11 without having sought or obtained shareholder approval, the preferred shareholder filed a motion to dismiss, which the bankruptcy court granted for lack of corporate authority. Circuit Judge King said she was going to decide just the case before her, and to do that, she based her decision upon a 1945 Supreme Court decision called Price versus Gurney, where the High Court held that state law determines corporate authority for filing a bankruptcy petition. Judge King said there was no statute or case law to undermine the applicability of that Supreme Court authority to her case. And at the expense of getting things not precisely correct, let me read what Judge King said. She said that there was no authority to deprive a bona fide shareholder of its voting rights and reallocate corporate authority to file for bankruptcy just because the shareholder also happens to be an unsecured creditor. However, that narrow ruling may not be quite so narrow as it seems, because Judge King also qualified her decision to say what she was not deciding. And what she is not deciding, if you can read between the lines, may actually be very helpful for corporate debtors trying to file Chapter 11 petitions. She said that her decision goes no further than the facts before her. She said that the case did not involve a creditor who, and I quote, somehow contracted for the right to prevent a bankruptcy, or where the equity interest is just a ruse. So those words leap off of the paper and suggest that Judge King is telling lower courts that if your status as a shareholder is a ruse, that may not work, or perhaps also it may not work if the creditor has somehow contracted for the right to preclude bankruptcy. Well, this is either a narrow or a broad decision, however you take it, but nonetheless, at least for now, the rules of the game are pretty much unchanged, and if there is a bona fide provision in corporate documents requiring shareholder approval, that's what's required. Well, come back next week for another edition of Rochelle's Daily Wire, and to read more about this particular case from the Fifth Circuit.